171, the people of the state of New York versus Harvert Stevens. Counsel?
May I please support Kristen McDermott on behalf of Harvert Stevens. Can I please have 3 minutes for rebuttal?
3 minutes?
Yes.
You may.
The Syracuse noise ordinance is very, very similar to the Poughkeepsie noise ordinance that was struck down by this court over 30 years ago when people beat.
How would you make it so that it wasn't? What should they do?
Well, I think one thing that they could do to fix it is to take out the blanket general prohibition contained in 40-4 and just stick to the 14 specifically enumerated acts, so that instead of just having this very broad, vague provision that any type of unnecessary noise could fall into, give people actual guidance of the types of acts that can fall into the ordinance.
The unnecessary noise is capped, right? It's not. It doesn't just say unnecessary noise. It is capped.
It's defined in the statute with an extremely broad definition that the Trap Rock Court said was permeated with vagueness.
But there's a big difference, isn't there, between trap rock in this case in terms of the reasonable person standard?
That is correct. That's the big difference. But the Supreme Court looked at this and found that that one difference wasn't enough to take the statute out of the reach of trap rock, and it still failed the void for vagueness test.
But isn't there, to me it seems there's a two-part issue. That is clearly a big difference, but also with trap rock, isn't it that if you violated a specific provision under the terms of that statute, you automatically violated the general provision? And so in this case, if the indictment reads, it's only charged as subsection 16, right?
The indictment did only refer to 4016B, but I would disagree that that's not violating the general prohibition. The lower court looked at the entire statute together because the way the statute's written, the 14 subsections are declared to be prima facie evidence of a violation of this article, not distinct prohibitions in and of themselves.
Right, but it is a little bit, and I agree, that is a difference. It is different, though, than the trap rock statute where you were automatically found to have violated the general provision. So isn't it really, as applied in this case, they did what you're saying they should do, which is specify the specific conduct within the subsection as the violation of the noise ordinance?
Well, even to the extent you only look at 4016B that Mr. Stevens was specifically charged with, that section still references unnecessary noise. So that still requires a reference back to 40-3U when you have to look at the definition of unnecessary noise.
But then you get into the Judge Fahey's point, which is it's defined as a reasonable person standard, so you get rid of the first, let's say, trap rock issue, right? It's really the second one then, which is it a violation of that general provision, which there were issues with in trap rock? And here it seems to me you can read this not to have that.
I do think it's pretty much the same in both statutes. I mean, I do understand the distinction, but I still think that the blanket prohibition, it was violated here. But in any case, even the reasonable person standard doesn't help with the definition of unnecessary noise very much, because you've got the 10 standards that you're supposed, or the 11 standards rather, that you're supposed to look to see if noise is unnecessary, and 10 of those are the very same standards that Trap Rock said were nothing but abstract lines of inquiry that didn't provide any guidance. Those are inherent.
But didn't you just say when I asked you, you said if you get rid of the unnecessary noise thing, then it's fine? Because I said, how would you fix it? And you said, well, you get rid of that general provision.
I think that would be one way to. I mean, you would still have to. Sorry.
I apologize. Is it then fixed?
No, you would still have to go into 4016B and take out the word unnecessary, because that's what's adding the vagueness in that specific provision. So you would still, I mean, once you, in 4016B, first the noise has to be heard 50 feet from a car. Then there has to be a separate look at, is it unnecessary
Right,
noise?
so if you've got a volunteer fireman who's going to a fire and he's got a siren on, it's necessary. So that would be okay.
I think that would be fine under the statute, but I think that this mostly refers to music coming out of car radios. And so people would have to, we don't know what music coming out of car radios is necessary or unnecessary, because the statute just has these 11 vague, subjective guidelines for us to look at, and people don't know how to tailor their behavior.
Well, the point is the noise level, right?
That's all.
The point is the noise level, that's what's disruptive. Am I missing something?
The noise level is only part of it. It can't be the entire determination. So once you hit the 50 feet, that's not the end of the story. Then you have to say, is this unnecessary? So
you're back to what Judge Piggott just said, which is a fire alarm versus somebody who's in a library. You know, the standard would be different. But the problem was, when you're in the second part of the analysis here, which is whether or not the specificity of the statute is sufficient so that someone would know how they're supposed to behave in a particular place, it seems that you're really pointing us towards a requirement to have a decibel level standard set. Are you?
I think that would be one option. I don't think it's necessary. I think
because that's never been required.
Right. I know that some noise ordinances do have decibel levels just to provide that kind of objectivity, and I think that would be a good option. But there are other options. You can have just distance requirements or time requirements or just any sort of objective measure where people can look and tailor their behavior to know whether their noise is violating statute rather than just, well, would a reasonable person think that this music was unnecessary in this situation?
But didn't we say in, I'm not pronouncing this right, I'm sure, Becolis, that case, that you can define unreasonable noise?
Becolis is different, just because that's a disorderly conduct statute, and it didn't just rely on the objective standard. There was also an intent requirement in that case, which we don't have here. And the case itself said that it's distinct from trap rock because all of the acts prescribed by the section are publicly offensive, which has a narrowing effect. So yes, there are some circumstances in which you can define unreasonable noise, but this is a vague statute that doesn't fit into that Becolis.
And it seems the federal courts have found this to be fine constitutionally, right? This type of definition of unnecessary noise.
Well, I would just point out that Markavich itself was a case on a motion for a preliminary injunction.
Right.
But yes, Markavich does, I think there's just a difference between the federal courts and the state courts in this area. I would just point out that Markavich refers to its own precedent of Howard Opera House versus Urban Outfitters. And in that case, that actually is just directly in conflict with trap rock because that's not an objective standard. That case defines unreasonable noise as that which disturbs, injures, or endangers the peace or health of another. So that case would have the same problem that trap rock had, that you could have the boiling point of a particular person or a cantankerous neighbor, which trap rock said was unconstitutional. But the federal courts have said that's okay. So I think that the state courts are just applying a more protective due process clause in this area, and that this court should follow its own precedent of trap rock rather than those federal.
But I still go back to the reasonable person standard, counsel, and trap rock was decided over 30 years ago, and things have, technologically things have advanced in 30 years, and the noise, as you've mentioned, comes out, it's usually directed to music coming out of cars, and now that, cars can be sort of tricked out with huge stereo systems, and you don't really need, a decibel standard or almost anything else to say this is unnecessary noise. I don't know if this happens in Rochester, but I live in Manhattan, and from my house I can hear people going up and down the streets with their stereo systems blaring. I wouldn't care if it was opera. I wouldn't care what they were playing. It's just noise. It's really unnecessary if you're in your house. So why is that so vague when you have a reasonable person standard?
Well, because I think everything that Your Honor just referenced was just volume. So if they had just said 50 feet from a car, that's not vague at all. That's something people could clearly follow, and you don't need a decibel standard. But they didn't. They added this. They injected this vagueness into it by having an unnecessary noise requirement in addition to that. And
I'm surprised you make that argument. In other words, the police officer can say, I heard your car radio 50 feet away. I'm arresting you for violation of an ordinance. It just seems to me that by arguing this objective standard, you're making it harder, making the ordinance tougher in terms of enforcement and its purpose.
Well, in some ways that's true, but the point of the void for vagueness test is can police officers apply this fairly, and can people know how to tailor their behavior? So even if it's a tougher law, I mean, that would be up to the Syracuse legislature of how tough should their law be, but even if it's a tougher law for defendants, at least they'll know how to follow it. At least they'll know how to tailor their
So if
behavior.
a baby's crying and it's 50 feet from the car, and you say, I hear that baby crying, I'm giving you a ticket. Under your new ordinance of 50 feet.
I don't think-
It's a clear violation.
I think that it has to be sound coming from the car itself.
So, well, I'm asking you for your ordinance, and you said your ordinance says if it's noise 50 feet from the car.
I mean, that wouldn't be I wouldn't pass that law as a legislator.
Okay.
But I would have either a decibel standard, a distance standard, or something clear that.
But how do you differentiate between the siren on the emergency vehicle and the baby crying, or, some other thing?
I mean, there's specific exceptions put into.
Right, but can you capture all of the nuances that way?
I think that you can. I think you can capture. I think you can capture what you need to. Even to the extent that that would be difficult, I don't think that the answer is to just throw up your hands and put an incredibly vague statute out there that's very difficult for people to tailor their behavior to.
How is it difficult to tailor your behavior when you know you're sharing your music, whatever it is, with the rest of anybody who's traveling, whose neighborhood you're traveling through? I mean, I don't, unless you're absolutely deaf, you have to know that the sound that you're making is traveling far beyond your car.
But again, we can't just look at volume. There have to be some factor in addition to volume. So you could say, I know my car radio has to stay below this volume, but there's a second part of this here that none of us really know what it means. Is it unnecessary? And so we can't just look at how far is the noise traveling.
But when would it ever, that's what I'm saying, when would it ever be necessary to share your music with the entire neighborhood? When is that necessary?
I don't think it's ever necessary to play your car radio in the first place. I mean, none of this is necessary strictly. The question is, how do you know if you're violating the law?
Thank you, Ms. McDermott.
Thank you.
Counsel?
May it please the court, James Maxwell for the people. Ask you to affirm. The statute, and my view is proper, and I ask you to uphold it. One case I want to mention, along with Beck Hollis that Judge Garcia mentioned, is an older case, People versus Byron, which talks about it at F with muffler VNT statute. And in that case, this court wrote that the statute was okay, and it's common knowledge of how much noise is too much noise. And I think that helps us as well.
So what's the point of unnecessary? Because it means more than just the volume. Is it to carve out for emergencies, or what seems obviously nonsensical to apply this kind of ordinance to a baby crime?
Yes, I think unnecessary is necessary because it makes the statute work. It makes it cogent. You're not going to arrest the firefighter for blaring the horn to go respond to a fire. You're not going to arrest the mother or father of a child who's crying. But I think overall, the objective, the statute is written in two things that help it distinguish it from Trap Rock. This particular subdivision, or this particular part of it that we're using, goes to in cars. It goes as the 50 feet, and the disturbing person of reasonable, normal sensibilities. I think that all goes to that.
Does that part of the reasonable person of normal sensibilities address your opponent's claim that this just gives too much discretion to the officer who may not like the kind of music that's being played?
I believe it does, and the kind of music I don't think matters. I mean, it could be NPR, especially if in their fundraising drive time. But nevertheless, the 11 standards that are listed, they're not a must. They're there. They're not particularly helpful, perhaps, but they're there. But I was looking at Trap Rock, and I can see where the court landed. It was a business, a crushed rock business, and for reasons unknown, they built residences right near there. And I think that there was both the general and specific part of that statute, or ordinance that was involved.
And a police officer in Syracuse, New York, if there is a a impromptu parade down Salina Street celebrating the fact that unbelievably the Syracuse University football team beat Notre Dame or something. He'd let that go. If, on the other hand, it's the same parade, only they're celebrating the New England Patriots defeating the Buffalo Bills, they would all be under arrest, because that is wholly unnecessary. you see I mean, you have some play in there that may not be, I think, Counsel's point.
I think that there's an acceptable amount of play. There is some discretion in police work, but they also have a duty to enforce the law and an ability to enforce the law. And so I think that carries over.
So what if you happen to be in a hotel parked across the street from a construction site, and the construction vehicles are on the public highway and they are quite loud, and your room just happens to be, let's say, actually 50 feet away? Can't imagine where I'm getting this hypothetical this morning. Does it fall under this ordinance?
You stayed, never mind.
Don't ask, don't tell.
Okay. But again, going back to this statute, it's particular to cars on the roadway, and a decibel level I don't think would be practical either, because unlike let's say tint on the windows, which is a constant, the noise level isn't constant.
So, some municipalities have put them in.
Yeah,
Struggle with that. You know, it comes up in the context, I think, of bars near residential neighborhoods and how to measure the sound at various times. For instance, what's reasonable person may think is okay at 10 o'clock at night, at 4 in the morning may not be. That's where those kind of standards come in. So some have used them.
I'm sorry, let me just go back to the hypothetical. Are you saying that my example of the vehicle that's part of this construction site would not fall under this, because motor vehicle is applying to what?
Well,
I mean, I'm sorry, did I miss it? Is motor
no,
vehicle
there's motor
defined?
vehicle in the statute
No,
on
but
the
is it
public highway.
defined?
If he's on a construction site, he wouldn't be on the
No, but on the
public highway.
road.
On the
All
road,
right.
yes.
They're doing construction at, let's say, a building. You're building a building.
Yes.
Again, I don't know where I'm
And-
getting that hypothetical, but the construction vehicle is parked on the street, on the road,
Well,
excuse me.
It's
And it's
kind of,
really loud.
it seems kind of like that's closer to Trap Rock, because that was a commercial setting. But I still think the statute here is going to be applied fairly, that the police will know what they're dealing with. They're knowing when the noise is just
So I guess, well, that's what I'm saying. Let's say you've got the construction vehicle, it's making, as I say, very loud. There's no doubt, very loud.
Right.
That's the way that vehicle works, to do this construction, it's gonna make this noise. And right next to it, you have the car that's parked playing, take NPR, it doesn't matter to me. The radio, similarly, just as loud.
Well, again, to go full circle on our argument, that might just illustrate the necessary right there. How are we going to get this construction debris away from this site? It's necessary. It's maybe short-term.
Mr. Maxwell, can I go to just one other point? And it hasn't been brought up yet, and the council will be able to respond with them. But the third point I think that's raised about the defendant's failure to be present at the suppression hearing, and that seems a fair amount of case law, and it seems to be against you on that.
Well, I think if a fair application of Dokes would help here, because it's factual, yes, but is it a fact that the defendant has any knowledge or ability to contribute to? Somewhat similar to if you're up at the bench trying to decide whether to keep a juror, and maybe the juror's up at the bench and it's talking about personal commitments and this and that and the other thing.
Well, that's the argument that the defendant's presence wasn't necessary, but you could pretty much apply that rationale to any situation then where a testimony is being given. It's much different when you're making a procedural determination like scheduling. You know, that kind of thing. It's easy for us to see that. But how a defendant's presence wouldn't be necessary in the context of testimony, you don't know until the person testifies, I guess is the problem with that analysis.
True enough, but in this particular case, in the previous proceedings, with the defendant there, this was discussed, or we're going to have
No, I understand that, and this guy was out anyway, and so I do understand that, but the problem is the rule we're making here, it's applying to the whole state in this circumstance then. And it's hard for me to see, I can see a rational argument for it, but how do we distinguish the necessary presence here from some other case with an entirely different factual circumstance?
I think not so much distinguishing, but looking at Dokes and talking about does this defendant have anything to offer on this? He kind of showed us he didn't by not showing up, but also it's a very peculiar question about what was the knowledge of Detective Bala. And in the defendant's brief, he suggests, well, what if the defendant had overheard him talking about the provision or something? I think those examples are far-fetched. And I think this is just a clear example of there was nothing he had to add, nothing he had to contribute, and his decision to stay away shouldn't trouble the court to say we got to send this back for another 5 minutes with Detective Bala in front of the trial court. Again, I don't really know how to go any further with it because I think Dokes, if you look at the language of Dokes and the meaning of Dokes, I think that controls.
Was this argument made in the appellate division?
No. The third point, it was not.
Well, I understand Judge Garcia's point. The problem is it's either an error, motor proceedings error, or it's not. This issue comes to us, I think we're kind of stuck with it. We can't avoid it all.
Well, counsel didn't complain, and I think at the subsequent hearing, the defendant didn't bring it up that he was not there.
Well, and along those lines, I think there's one case where a defendant's there for the morning of a hearing and doesn't come back for the afternoon, and I think that was upheld. This is a different day, but it is a continuation of a hearing. And the judge, with the defendant there the previous time, says, this is only going to take 10 minutes. We're going to do it at noon between other things I got to do. And the lawyer says, well, I think I told him he didn't have to be here.
But the lawyer was there.
But the lawyer was there. And next appearance, they continue on from there. And the lawyer could have said, Judge, we have to have Detective Bala back. My client just told me a great cross-examination question. That didn't happen.
Did the court at some point prior to all these proceedings inform the defendant that, of course, he could be present at the proceedings?
Your Honor, I don't remember.
Yeah, you can give him Parker warnings.
No, it's not a Parker warning situation, and I'm not saying that you can't reach it because it wasn't brought up the appellate division. If I may have just another few seconds.
Yes.
Very fitting to me, personally, that we're here in this building, in the courts here today, because this is where I first encountered Judge Piggott. And this is my last chance to argue in front of him. I appreciate all the courtesy you've always shown me.
Nature Finch, Mr. Maxwell. I keep reading you on Nature Finch.
We'll
talk
next
about
year
that.
we'll get together and talk about it.
Counsel?
Good afternoon, Your Honors. John Sickinger on behalf of the City of Syracuse. I guess to come full circle from what Mr. Maxwell said, Judge Piggott, you swore me in 12 years ago. So, as I think Mr. Maxwell touched upon, the city's ordinance contains the objective reasonable person standard, and that is, it's just black and white. That's what separates it from trap rock. That's what separates it from the other instances which the appellant contends are applicable here, where noise ordinance statutes have been found unconstitutional. As we noted in our brief, quite simply, based on common life experience, a person can determine what's reasonable and what's not.
So my hypothetical is the construction company liable under this ordinance for that noise?
If a reasonable person would find that that noise was unnecessary, yes. And again, a reasonable person would take into account
Well,
the...
no. Unnecessary noise means any excessive or unusually loud sound or any sound which
annoys. So now we're just annoyed, and it's a reasonable person with what did you use? Normal sensibilities, understood. But let's say that construction truck that's even louder than the car next to it, that's already very loud and playing the music very loud.
Well, I
Are
think
they liable?
if you turn to the 11 factors that the ordinance enumerates, and then you determine that a reasonable person with normal sensibilities, which again goes back to the common life experience, if you can determine under that rubric that the person has created that noise, then yes, potentially they are. But again, common life experience would say if you're going to do that at 5 in the morning, it's very different from doing it at 2 in the afternoon. And again, that's where the common life experience comes in to delineate those and to
So
apply those 11
it can be at
factors.
any decibel as long as it's not at 5 in the morning?
Well, no, certainly not. But at 5 in the morning, there's probably what would be reasonable at 2 in the afternoon is likely
Well, I'm
to be
just not
reasonable
understanding
at
why
5.
the construction company or the person driving, I guess the truck, doesn't have some accountability under this statute, but the individual who's playing very loud noise, their radio very loudly in the car I'm just not understanding the distinction yet. I'm not understanding why you're trying to make a distinction. It sounds to me like they fit.
I think it would, and I think it would also
It
come
doesn't
back-
matter, what I'm saying, it doesn't matter. 5 a.m. may matter under certain circumstances, but
Certainly.
but not for that construction, right?
No,
At 2 in the afternoon.
I don't believe it would. I also would think that you would, again, get into what's necessary and not necessary, but I don't think you need to go that far. in
Well,
your-
no, I want to clarify that. Yes, the category or the phrase is unnecessary noise, but as defined, says, or any sound, I'm just picking one of them, a noise. A noise. Right? Again, with the qualifier, agreed, of a reasonable person of normal sensibilities, but a reasonable person of normal sensibilities could certainly be annoyed by a construction truck that is at 100 decibels, right?
Certainly, but if you include the reasonable person standard, I think that specifically has been addressed in prior case law, because if you look at, I think in Bacolas, if I'm pronouncing that correctly, which was talked about earlier, they analyzed trap rock, and they specifically found that it was unconstitutional because the ordinance in that case rested upon the malice or animosity of a cantankerous neighbor or the boiling point of a particular person. And when you include the reasonableness requirement in the Syracuse ordinance, you take that sort of situation
Yeah, so
away.
I think you're getting back to the prior argument. Unnecessary is necessary. In this example, construction is required. And so maybe that's your argument, that we as reasonable people might say, well, you got to do construction. Construction is a little loud. We're going to have to deal with it for a period of time until the construction is completed. Versus someone sitting in their car blasting their radio.
Correct.
Can we look at this as just the charge of Section 16, other than in Trap Rock where you had to, by nature of the statute, look at it as a violation of the general provision?
So if you look at the particular violation of one of the enumerated instances.
Right,
without
16 here, right.
Necessarily being a violation as a whole. Yes, I mean, it's not like Trap Rock where if you violate one, you automatically violate the statute as a whole. These are, factors to be considered, specifically noted in the ordinance.
And the issue I have with that, though, and I see it and it's the way it's charged, though, they are just prima facie examples of prima facie violations of the statute. So is it really that clean is the issue I'm having with that? Is it really that clean that you're charging only the 16 subdivision, which has these specific factors in it, or necessarily are you charging essentially the general provision here?
Well, we're indicating certain circumstances which would be considered, which I guess would give guidance to any person who's going to create noise within the city of Syracuse, that these are 11 enumerated factors which would contribute to that. But I think
Not those, though. The provision you're looking at here, that was charged in the indictment with being on a public vehicle and however far it is. That provision is very specific. And are we looking at that in terms of constitutionality, or are we looking at the entire scheme here?
in terms of looking at the statute as a whole, or then the unnecessary noise at 50 feet from a vehicle requirement? Well, I don't know that you would necessarily need to distinguish the two to find that the ordinance itself is still constitutional. Because if you're going to, again, if you put in the qualifier of a necessary noise, you can determine then on that basis, again, through common life experience and a reasonable and a standard, what would be necessary versus unnecessary. So I don't know that you have to parse it down into that small a category.
Well, is it almost, though, like a definition? You have specific violations, and you're using the definition of unnecessary noise in Section 16, right? Because you still need unnecessary noise in whatever the situation is there. Is it more like that's a definition you're incorporating in Section 16, or are you violating the general provision?
No, it would be, I think it would be more of a definition. You're giving, I would say, guidance as to what the conduct to be proscribed would be. So I think that's the way I believe the city would interpret it. Again, just to summarize, the clear difference in these two comes down to, again, the reasonable person standard. It's very simply a matter of Trap Rock and the ordinance in the city of Poughkeepsie did not contain that standard. In the city of Syracuse, it does. And I think everything else is subject to that particular argument, and I think it in itself makes the ordinance constitutional.
Thank you, Mr.
Thank you.
Mr. McDermott, do you care to address Mr. Maxwell's argument with respect to the presence of defendant at the reopened suppression hearing?
Yes, thank you. The defendant's presence was required here. This was a factual suppression hearing. He had the right to be present. It's a constitutional right. Any waiver has to be judged on constitutional standards, and there was no waiver. There was no inquiry as to why he wasn't there. There were no Parker warnings given. There was no explanation.
What did his lawyer say?
His lawyer said, I spoke to him this morning. I may have alluded to him that his presence wasn't necessary, but he didn't tell me whether or not he was planning on coming.
And then in the subsequent proceedings, he was present. He didn't object to the fact that he wasn't there on this occasion.
That is correct, but this
So
is
at what point does the court have to say, I don't care that you didn't care to come, I don't care that your lawyer was there and said what he said, and I don't care that you're here saying that you don't care that you weren't there, I'm going to have to start all over. I don't, it seems to me we're really into a preservation issue here. You know, if he didn't object, why are we complaining about it?
I think it's well established that this is a mode of proceedings error, that an objection isn't required. I mean, there are any number of reasons why maybe later he wouldn't have objected. Maybe he just didn't know that was something that he could do. He might have thought, oh, I missed the hearing. You know, that's just too bad for me. And maybe that's what his lawyer told him. But in any case, preservation isn't required to reach this issue. Really, the error was made at the time of the hearing. The court could have simply said to counsel, I'm going to recess for 15 minutes. Can you call your client back and ask if he wants to be here, and gotten a waiver? And the court acknowledged on the record that at that point, counsel couldn't waive her client's presence because she didn't have that from him.
That would be enough if they went to the phone and came back in and said to the judge, I talked to my client on the phone and he doesn't want to be here. That's enough?
It may have been. I know there are cases where counsel can waive her client's presence if she has an actual statement from him that he doesn't want to be there. Here, she didn't have that. It might have been enough if she had some actual directive from him, you know, please do the hearing without me, I don't want to be there. But
So if we agree with you, does that incentivize defendants not to show up?
I don't think so.
To create an appealable issue?
I don't think so, because I think if this is done correctly, they would have been given Parker warnings, and then there's no problem, because then they would have been told that the hearing could go forth in their absence.
If we agree with you on this issue but disagree on the other two issues, on the constitutionality, if we reach that, we don't have to reach the other, it would go back, right?
Correct.
And then your client would be in a position of looking at this case with no deal and an open docket, right?
Correct. Before the suppression decision was made, he would be starting from scratch. If I could also just distinguish Byron very quickly. That was a muffler case. That is the kind of case where a reasonable person standard should be applied, because we all understand how much noise a muffler should make. We don't all understand what type of noise should come out of a car radio. It's just very, very different.
Thank you, Counsel.
Thank you.